Hello, welcome once again to the Law Professor channel, where we discuss various issues of law, particularly law of tort and private law. In this presentation, we shall be looking at the damages and the remedies available to an employer who has been found to be vicariously liable. What are the remedies that he could pursue against his employee for, in law to recover some of the losses that he has had to take on by virtue of that relationship. And learning outcome is quite simple. To just I will identify the you would identify the various forms of actions that this employer could pursue, the employer could pursue, and see the various remedies in terms of practical steps that the employer could take where he has been found to be vicariously liable for the tort of the employee. So these are learning outcomes to understand the compensations available and to understand remedies that the employer could pursue. So in terms of the damages, very simply, damages means an award of money for compensation. When we talk about that, in tort, we are talking in this context about what are the financial losses that you could put in the case that borders on the employer's liability for the tort of the employee during the course of employment. And in this respect, you know that in a vicarious liability claim, you are bringing an action usually against the employee as the primary tort officer because you must establish that a tort has been committed, and then you bring an action against the you join the employer to the suit. So vicarious liability is a form of joint liability, and the plaintiff can actually claim damages from one of the two of them, jointly and severally. So vicarious liability is a form of joint liability. And the plaintiff might also, the selective is going to might decide to sue the employee alone if he feels that that person is in a position to pay for the loss, or he may sue the employer alone. Especially when he knows that the employer has a deep pocket, is financially stable and able to, pay. The employer's remedies. Basically, an employer can seek to indemnify himself under the rule in Lister and Ramford High School Storage Company. That rule allows an employer or the insurers of the employer to go against an employee after they had paid the damages to the injured third party. In Lister and Ramford Ice Company, it's a very interesting case. It was a case where the employee, whom we call Junior Lister, was in the course of employment driving a truck, and his father was also employed by the same company, and his father was supposed to be, directing him as he reversed the truck. Lister Junior, the driver, was negligent, and he reversed into his father and injured him, injured Lister Senior. And the father successfully sued the company, claimed damages, and was awarded damages. The insurers of the company who had to pay the damages then had proceeded against Lister Junior in subrogation, to recover the amounts that they paid in damages against for Lister Senior. So they sued Lister Junior, the employee who caused the injury. And then they were successful in that claim to recover. So under the principle of subrogation. So the case, the principle in Lister allows a claim where an employee who is in the course of employment causes, injury to a third party if he's negligent, and that third party suffers as a result. The employee is liable in damages, not only as a primary tort officer directly to the third party, but also liable to his employer or his employer's insurance to recover damages which the employer or the insurer have had to pay to the third party. So because they've had to pay damages to Lister senior, they went against the employee and they successfully recovered damages. So the principle in Lister and Ramford High School Storage Company also permits the employer to and the employer himself to sue the employee for breach of contract. In Lister's case, the court said that employment of Lister Junior has inherent in it a duty to take care in the performance of your responsibilities as an employee. And when you don't take care, the employer could proceed against you, and so you can proceed for breach of contracts to take care. The employer could take the practical step of just dismissing the employee if they felt, especially if it's a recurring sin, if you've seen that there's a history, a system, of negligence and incompetence, one practical step, because that is the essence of vicarious liability, to deter employers from employing incompetent people, to watch out that they do not allow a dangerous person, a dangerous state of affairs to continue in the course of their employment. Okay. Then under the English Civil Liability Commissions Act, which applies in England, it allows employers to recover some or all of the damages he has had to pay for the tort of the servant, because we said that the employer and the employee in the vicarious liability claim are like joint tortfeasors. So it could recover all or some of those damages that the employer has had to pay, apart from the action for breach of contract to take care. Okay, and that same principle applies under Nigerian law. If you look at the law reform torts law, for instance, that of Lagos State, you see that principle of contribution, being, statutorily ingrained. So these are some of the practical remedies that the employer could take, against against an employee where the employer has been found to be vicariously liable for the tort of the employee. The whole essence, like we keep emphasizing, is the fact that there are some responsibilities that the law would not allow you to take for granted. And so it operates like a system of checks and balances. So when the employer knows that they can be liable, they be careful in terms of the persons they employ. And then if they have had to pay damages because of vicarious liability, they also have a recourse. So it is, against the employee. So it is not likely that employees would behave carelessly, believing that if anything happens, they can get away with it. So that essentially summarizes some of the available remedies that the employer could pursue against the employee. I'll see you at the next presentation. Don't forget to subscribe, like, and share the video. Thank you.